Thank you. Good morning, everyone. As a former trial court judge, I want to say it's lovely to see so many faces. Because when you move to the Court of Appeals, you just see lawyers. So for those of you who are not attorneys, a special welcome. We are going to begin case call momentarily. And we have one matter that is at the top of our docket. I want to thank all counsel for adjusting your schedules so that you would be ready to go right out of the chute. It is greatly appreciated. We have some friends from the media who are here. We want to welcome them as well. We did have a last minute request for some media coverage, which was granted, but I am reminded that ordinarily our friends in the media should request permission to come 3 days in advance of the hearing. So we were glad we were able to accommodate you, but future point of reference, please try to reach out ahead of time so that we can adjust and accommodate appropriately. So I'm Michelle Rick, and I will be presiding over our case call today, and I'm really delighted to be with two good friends and colleagues, Judge Yates and Judge Shapiro. We are going to call our first case, and after we are concluded with that matter, because we have so many of you here who might be observing, we're going to take a break so that we can transition out, and then we'll begin the remainder of the docket. And I think that we'll just get right underway and call that case. It is item number 16 on the panel 6 docket here for October in Grand Rapids, and that is the matter of Adeline Hambly versus Ottawa County, and the docket number is 365918. So we have counsel seated at the appellee's table. I see my one of the familiar faces from my trial court days. It's great to see you, Mr. Kallman.
Good morning, Your Honor.
Good morning. There are two other individuals who are endorsed for argument on behalf of the defendant. Will they be joining you, Mr. Kallman, or are you going to be personing the ship?
I will be handling it this morning, Your Honor. We did have, if we could have my son zoom in also. I was worried that if I lost connection or something in midstream, that then he could pick up and take over, if that would be okay with the court.
My colleagues have any objection to that?
No.
Okay, there's no objection to that, Mr. Kallman. I can only see you on the screen, so is he already in the
No,
Zoom?
he was coming in by Zoom from another location. He should be there.
Well, I'm going to ask our. Okay, they apparently have him in a waiting room unless or until he is needed. Is that sufficient, or would you like us to get someone from IT to have him join you on the screen?
Well, if he could join on the screen, I would appreciate it, Judge.
Okay.
If it's not too much of a hassle, if it's a problem, we can go ahead, but.
Okay, all right. We'll get a message in, but I think we probably ought to start.
Okay.
All right, thank you. So you are here on behalf of the appellant, Mr. Kallman, if you want to go ahead at this time.
Thank you, Your Honor. May it please the court. Appreciate the court's courtesy in letting me appear by Zoom today. I'm appearing on behalf of all appellants. Ottawa County respectfully requests that this honorable court reverse the trial court order declaring appellee as the permanent health officer and also dissolve the preliminary injunction in full. This case, we believe, is simple and clear. The lower court erroneously held that if a county board of commissioners makes a motion, vote, and decision at a public meeting, and then records that motion, vote, and decision in its official written minutes, but then changes that public motion, vote, and decision by allowing the board chair to sign a new and different resolution privately, not at a public meeting, that changed and altered the motion, vote, and decision of the full board, that's all right. That's what the
Was
board
there unanimous?
approved.
I'm sorry, Mr. Coleman, wasn't there unanimous agreement with respect to the initial motion and the composition of the board as it existed in the earlier December board?
Yes.
Okay, so how did that change then? I'm not.
Well,
understanding.
yeah, their decision, as I'll get into here, has 3 contingencies that were required before Ms. Hambly would be appointed as the permanent health officer. The resolution that was subsequently signed by one person, the board chair, changed and altered that decision. So that's the point, and that's the crux of this case.
You keep saying it changed it, but why isn't the more logical way to read it that the approval of the commission came first, and then she had to meet the other 2 requirements, and the approval of the commission was part and parcel of what they voted on December 13th? I mean, it just seems to me that in order to adopt your construction of this, we have to not only disregard the way the resolution was written, but we also have to disregard the sequencing of events that was contemplated by the motion.
Well, Your Honor, I don't believe we're disregarding the motion. We're actually adhering to the motion. If the motion had said, we're appointing Ms. Hambly as the permanent health officer once she clears MDHHS credentials and once she passes a background check, I would agree with you. We would not be sitting here. But that's not what the motion said. And the motion said it had a 3rd contingency, which was actually the first one. It required a further vote and approval of the board. And that makes sense as we get into this because they had to have MDHHS approval prior to appointing Ms. Hambly. And again, Judge, the Youngkin case that we cite in our brief, I think, speaks to this. It's not the court's position to look at something that a legislative body does and decide whether or not it makes sense or is logical to the court.
But wait. On January 3rd, the new commission appointed somebody else before they had approval for MDHHS. Was that an unlawful act?
No, because they did it differently, Judge. They put in Ms. Hambly as the interim health officer because of the fact that there was no permanent officer at that point. It's part of the reason. And then secondly, when they appointed Mr. Kelly, they did not require a further vote, and they did the same thing. And they said contingent on MDHHS approval and passing the background check. So again, it wasn't an appointment that day. And actually, Your Honor, that kind of makes our point. Nobody has assumed or argued since January 3rd that Mr. Kelly is the permanent health officer, even though the board made that motion and made that determination and passed it. Nobody has argued that Mr. Kelly is the current health officer, but yet that's what they're trying to do based on the motion in December of 2022. That action was to sign a resolution.
Mr. Kelly is still awaiting MDHHS approval. Ms. Hambly received MDHHS approval. You even conceded that in your brief, that she passed the background check and she got MDHHS approval, right? So the other
a week later,
right? The other 2 conditions are met. And so if we logically sequence the decision-making of the commission on December 13th, it was first, we approve. Second, MDHH approves. Third, she passes the background check, then she's good to go.
Well, again, Your Honor, that's not what they did. They didn't pass like the board did on January 3rd. They passed a motion that said, we approve Mr. Kelly and now do MDHHS approval and now do the background check and we're good to go. That's not what they did on December 13th. They added another approval by the board. That's what they said. That's what they did. And under Youngkin, the court's supposed to carry it out, whether it makes sense to the court or not.
When one of the judges starts to talk, you're supposed to stop.
I understand, Your Honor. It's a little hard with Zoom. So
I understand. I didn't mean
as a general matter of Michigan law, though, a county commission speaks through its resolutions, correct? I mean, we've said that, the Supreme Court said that.
Well, Your Honor,
what you're suggesting is the equivalent of digging back into legislative history or comments made during the course of a debate on the floor to override what the ultimate act is when the legislature, for example, passes a bill. And I don't see why we would accept that invitation to create chaos in determining what a county commission did by looking at every scrap of information we can get from a meeting to try to figure out what they actually did when a resolution is clear and unambiguous on its face. I mean, don't you see the problem with that?
Well, Your Honor, no, I don't, honestly and respectfully. No, I don't. I see the opposite. A board speaks through its votes and its actions, and that's clear under the OMA, and it's clear in the case law that we cite. You cannot have a situation where a board votes to do one thing, then passes and then a resolution is later signed by one commissioner that changes what the board voted on.
Well,
That's what we're objecting to.
the person who signed was the chair of the board, and if
Right.
the resolution embodied the action of the board, where does the problem lie? I almost feel like you're arguing there's some semantic difference, and perhaps I'm missing that. What is the difference? Because I see the subsequent board doing exactly the same thing as the prior board.
Well, they didn't, Judge, because there was a third contingency. The third
Always
contingency
is.
was.
There always is that the board has to agree. The
But they
board-
didn't, but the January 3rd board, Your Honor, said, we're putting Mr. Kelly in. We approve him as the health director contingent on two things, MDHHS and background. The December board said, we're going to approve Ms. Hambley contingent on three things. Approval of the board, which again, it's a contingency, Judge. We cite Black's Law Dictionary, we cite the case law. A contingency means a future event. You can't come back later and say, oh, well, the contingency was met before they even passed the motion. I mean, that makes no logical sense. But the contingency was there.
The board chair, Mr. Fensky, before he called the vote on the motion, said, has she accepted the appointment? Answer, yes. Then he called for the vote. I mean, it just seems to me that any rational commissioner would think that they were dispensing with the first of the three elements when they voted to approve on December 13th.
Well, then they didn't need that contingency, Judge. Again, you have to look at what the legislative body here, the commissioner board, actually did. What they thought, parole evidence, and we cite the case law on that, is irrelevant to this. It's what they actually did. And what they actually did was put in the motion and vote and the decision that there had to be another approval by the board. That approval never happened.
I think
If
you
I
can
could go-
continue.
if I-
Yeah, let's talk about the injunction now.
Okay. Well, as far as the injunction goes, really, for the most part, that injunction has been vacated. The key part of it, which was that the board could not use 4611N, has been vacated. And in fact, the board is proceeding under 4611N because of some recent activity and actions by.
I know it really
Yeah.
isn't controlling us to the present case, but I'm curious, what is the basis for the argument that she now meets the statute through either incompetence or whatever else the standards are? Because I looked, there was some of that in the briefing, but not much.
Well, again, this is involving incidents and situations that have occurred since we've been in the court, since this action was filed. So and actually the underlying facts have nothing to do with this case. It's other actions that Ms. Hambley committed.
Can you just give me one or two, just so I have an understanding of the context? Because I'm
Sure. Sure. The board filed a 20-page notice of charges and notice of hearing that detail all of this, Your Honor. And it says very clearly that it's based on her public statements that were false and misleading to the public regarding the budgeting process and the budget for the public health department and those sorts of issues. So it has to do with her statements.
right. I think she opposed the
Misleading the
budget
public.
cuts and made some public statements that were deemed to have been insubordinate. Is that fair to say?
Well, I don't know so much insubordinate, but just false and misleading and causing panic and problems in the community by giving the community false information. That's essentially the charges.
Let me ask you a little bit about 46.11N, because it sounds to me like it has two fundamental operating principles. The first is it's a grant of authority to the commission. In other words, the commission may remove the public health officer if they do the following things. And then it's a grant of rights to the person who's going to be removed because it says you have certain due process protections and we put standards in place. So it seems to me that if your position is the commission can avail itself of the statute as long as Ms. Hambley can avail herself of the statute, that's where you want to end up here, because that to me is a straightforward application of Michigan law. And when in doubt, it seems to me the more sensible thing is to follow Michigan law.
Well, of course, agree with you 100%, Your Honor, and I believe that's what the board is doing with this upcoming hearing. Yeah, absolutely.
So your concern about the injunction was the breadth of it, and based upon the order we issued in June, where it landed was acceptable to your point.
Yes, Your Honor. And again, that's why I don't really know that there's much left on the injunction. Our clients are allowed to proceed and follow the law. And they had not done so because nothing had happened. I know Applee makes a point of, well, in March, when we were having arguments, that I had made a comment at oral argument that Ms. Hambley had not committed any actions or done anything that would lead to her being terminated under or removed under 4611. That was true back in March, but that is no longer true in the boards, in the at least in the charges that are being brought forward. And there's going to be a hearing on that.
The reason I asked the question is you're here on an application for leave granted. And so to a significant extent, you get to call the tune. You decide what you're asking us to consider and what relief you're seeking. And you're not seeking a complete dissolution of the injunction so long as we disagree with you about whether she is the public health officer, right?
Well, again, yeah, Your Honor, it's two issues. Is she the permanent health officer?
Right.
We don't believe she is. But the second issue on the injunction is we don't see the point of an injunction at all at this point. I mean, it essentially was gutted when 4611 was allowed to be followed. So we don't see the need for any injunction.
Why then pursue the first issue?
Well, again, Your Honor, we filed all this before this has happened recently.
We're here
last month or
today,
so.
and I'm not trying to be difficult, but if you're telling us all that matters is that we can move forward under the statutory basis, then why do we have to decide whether or not the decision on permanent versus interim health director matters? Sure.
Yeah, I understand what you're saying, Your Honor. And Judge Shapiro, I agree in that sense, but I still don't think that the issue's moot in this. And it's really kind of what we're talking about here. It's really not, because of the legal issue regarding the way this was done and the motion and the contingencies, and then and then the resolution that was later adopted that did not comply. So we felt the legal issue is still of import and needed to be decided whether or not a board of commissioners can make a vote in public, say we're going to do 1, 2, 3, and then later do a resolution signed by the board chair that only does 2 and 3.
But
as simple as I can make it.
It's not, Mr. Common, it's not just a matter of public policy. I think it's outcome determined to some degree, because if your clients prevail on issue number 1, they don't even have to worry about 46.11N, right?
Right, because 4611 is going to be followed and complied with, and that is upcoming outside of this proceeding. Absolutely.
No, I think you misunderstood the question.
Right. That's not what I meant. But what I meant was, if you win on issue number 1 and she is not the public health officer, then the effect of that is she doesn't come under the protection of 46.11N. And as a result of that, you don't even have to follow 46.
I see. I see. You're right.
I think what you're saying is, trust us, in good faith, we're going to follow 4611N no matter what you do with issue 1. But it seems to me that we can't just take a leap of faith on that point.
Well, you're right. I'm sorry, I did misunderstand the question. Yeah, again, if she is the interim health officer, then interim officers, the question of whether or not 4611N applies to an interim officer, Ms. Hambley's attorney has argued that it does. And so that could lead to further litigation as to whether or not it does or doesn't. I believe that the our clients will proceed ahead either way.
Any other questions for Mr. Coleman? Mr. Coleman, you do have time for rebuttal if you'd like to reserve your.
Yes, I would, Your Honor. I would appreciate that. Thank you.
Okay, thank you very much. Appreciate it. And now on behalf of plaintiff appellee, Ms. Howard.
Good morning, and may it please the court. My name is Sarah Howard. I am the attorney for the health officer of Ottawa County, Adeline Hambley, who is seated at council table with me today. I will start first with the issue of whether my client is the permanent health officer. The panel is correct that the Board of Commission does speak through its resolutions, just like a legislature would with a bill. And the language of the original resolution, not the revisionist resolution, is controlling. There's absolutely no evidence that the resolution was somehow drafted by one person and entered. It is common practice for the chair to sign the resolution after the conclusion of the vote.
But I think the county clerk has to sign it as well, and the county clerk is presumably the observer to make sure that it conforms with the action of the board.
That's correct, Your Honor.
That's the whole purpose of having a clerk sign it.
That is correct.
They had a dust up several years ago in Macomb County because the clerk wouldn't sign off on things.
Exactly. And the clerk signed this one, and there have been a number of allegations about how and when this resolution was written, but none of those are before the court, Your Honor. There's really nothing further for me to say that I haven't briefed or that the panel hasn't addressed on the issue of whether she is the permanent health officer.
Right.
Was there any change though? What I hear from opposing counsel is that there was some kind of change, this third requirement that the board had to vote. I mean, how can you kind of walk us through that from your perspective, please?
So I do not think the statements of Commissioner Kyers support the outcome that Mr. Coleman is hoping for here. There was a discussion about needing to vote to appoint her, and that of course happened when they took the vote. It's a strained interpretation of a motion that's made orally. And of course, the whole reason why they use written resolutions on a regular basis is to be clear about what they're voting on and what they're deciding about.
Is it correct, as I remember it, that the board chair asked before he called for the vote on the motion, has she accepted the appointment yet?
Yes, Your Honor.
So
There was,
it stands to reason, given the sequencing of the way the motion was made, approval, then DHHS approval, then the background check, that board approval was first, not last. Am I misreading that?
you're not misreading that, Your Honor. That's exactly correct. That is exactly the way it happened, the way it was intended to happen.
And is that consistent with how the board has operated historically?
Absolutely, Your Honor. And I think you're absolutely correct that if you were to get into the background of, let's watch the video of county commission hearings and see if what they said comports with the resolution, you're going to have a lot more cases in front of you about what happens at county commissions. And we're going to get into things like parole evidence that Mr. Coleman correctly says we shouldn't be
Sure.
talking
I mean,
about.
this is the same argument we were having a couple decades ago about use of legislative history with federal legislation. I mean, for goodness sake, if a bill is clear on its face, you can't go to a Senate report and essentially override unambiguous language.
That's correct, Your Honor. I would also point out that we have a statement against interest by one of the defendants who acknowledged to my client in writing, as was presented to the trial court, her appointment, her effective appointment as the health officer.
But that really doesn't even matter anyway, because the Supreme Court said unanimously that when you have a resolution clear on its face, that's the end of the analysis, right?
That's correct, Your Honor. It's really
7-0.
Yes. Yes, it's really more of a belt, suspenders.
And duct tape.
Yeah, exactly. Other types of security that she is in fact the permanent health officer.
Right. Well, let's move on to the next issue then, because the injunction is the one, I think, where the battle is going to be fought. Now, from the outset of the case, you've taken the position that your client can avail herself of 46.11N. And I think everyone seems to agree with you now. So does that end the discussion? We just send everybody back to the trial court, lift the stay and just say, follow Michigan law?
Unfortunately, it does not, Your Honor. So as we noted from the beginning, we think it's important that the injunction as it was originally entered by the trial court in this matter be reinstated as she originally wrote it.
But how do we have the authority to essentially deprive the county commission of power granted by the legislature to them?
Well, courts,
We could strike the statute if we exercise our power of judicial review and declared it unconstitutional, but that's the last thing you want us to do because that statute is real protection for your client.
I would agree, Your Honor. However, the whole point of an injunction is to prevent harm before it takes place. And where the circumstances are such as the trial court judged them here with all the parties in front of her, where the circumstances are such that there's concern that the law might not be followed, that due process might not be given by defendants, then there's entitlement to an injunction pending trial.
But hear me out on this because I think we're the wrong judicial body to ask for that kind of relief. Now, I know there's a stay in place, but as soon as we lift the stay, the trial court can get involved again. And wouldn't that be the place to go? I mean, to issue a preliminary injunction, you know this. I mean, you have to give the parties a hearing. There has to be an opportunity to present evidence. We're not in a position to hear evidence.
I would agree, Your Honor. This body is not normally set up as the body to hear that type of evidence. And, as noticed by the fact that I came back again and again with different factual developments. And to the extent that's necessary, that's what the trial court set up for. But the trial court's already done that. The trial court's already had a hearing on the motion for preliminary injunction and judged at that time that it was necessary to enjoin the hearing pending a trial, which under the court rules has to occur within 6 months of the issuance of the preliminary injunction. We would have already had the trial at this point if we were still back in the trial court. She would be, the trial court judge would be available to hear what has happened since and to take in everything that has happened in the months that have intervened and to make a further decision. But it's important to note that after hearing from the parties, hearing any evidence that was presented on the motion, she decided that it was appropriate to prevent defendants from having any hearing whatsoever until the trial could be had. And I think the developments since really shore up what she decided all those months ago.
But what's the legal basis for her to say that they can't avail themselves of MCL 46.11?
Because my client has filed a complaint alleging that there are multiple acts of retaliation and that there is an intent to remove her by any means necessary and that they're not going to follow the statute, Your Honor. I mean,
but if they don't follow the statute, there are consequences that flow from that. I mean, you already have a claim for wrongful discharge, right?
I do, Your Honor, but in this particular circumstance, there's not much that can be done to fully compensate my client afterwards if a court were to find due process was not given. The position of health officer is an important one that was enshrined in state law by the legislature, as was recognized by the amicus who filed a brief here, that it's important that they have due process protections to be able to do the important work under the public health code, Your Honor.
I don't know if I agree, though, that there isn't an adequate remedy. I mean, that it seems, as Judge Yates has mentioned, that there is an adequate remedy in the event there's a statutory violation as determined by the trial court. How is it inadequate?
Because here, Your Honor, we have defendants who have said to this court that my client's not entitled to due process in this hearing. They said that in their last brief, and we pointed out in our supplement why that's incorrect. She is entitled to due process at this hearing. They have declared that she won't be able to call witnesses. I think it is overwhelmingly evident that this is not an impartial fact finder, that they have wanted to do this since day one. They removed her without regard to 46.11 already within an hour of being sworn into office. They've already demonstrated that they aren't willing to comply with due process. To update the court further, yesterday morning at their Board of Commission hearing, it was pointed out by one of the commissioners that they weren't in compliance with 46.10, that the notice had been signed only by the chairman, not by a third of the commission, which is required by 46.10. And after going into an hour and a half recess, they came back and determined that they would reissue the notice with at least 4 commissioners agreeing to it and move the hearing to the 23rd.
Wouldn't it be better if we left it up to the trial court to try to sort that out by lifting the stay and letting the trial court take a look at the facts on the ground? The difficulty you're having communicating with us illustrates the problem of asking us for that sort of injunctive relief. I mean, you file something, you ask for immediate consideration. We scramble around for a day or two. We try to get an order back out. We can never have an evidentiary hearing. The trial court isn't restricted in all those ways.
I would agree with you there, Your Honor, but here's the problem. So it's October 11th today. They've moved the hearing to October 23rd. Yesterday I informed them I have to be in federal court on October 23rd, and I asked them to move it to a different date. For us to get back to the trial court to the point where we can ask the trial court for relief and present these issues to the trial court, we are running out of time for that relief. And I think that it's evident from her initial finding that should be respected by this court, that she had enough in front of her back when she made the initial decision that that was appropriate here. That we, because of the employment retaliation that we alleged initially, that we should be entitled to have the accelerated discovery and the trial proceedings before there's any hearing after a trial, if in fact the board still wishes to do that at that point.
Forgive me for seeming that I don't understand, but what do you, when you refer to the trial, what are you referring to?
So my client has made claims already under the Whistleblowers Protection Act and other claims, Your Honor. And then there have been, as Mr. Coleman suggests, we also believe there have been intervening events since the initial orders that would require amending the complaint here. Your
So
Honor.
if we were to provide an opinion in order within X number of days, I mean, if we accelerate that, as we have accelerated many requests in this case already, would that provide you with what you need so that you could address these issues properly before the trial court as it pertains to 4611?
So long as we still had time to make it to the trial court and the trial court could hear us before the date of the eventual hearing in this case, Your Honor, yes.
Likely October 26th.
October 23rd at this point, Your Honor.
Okay, but I know that Mr. Coleman knows this as well, that accommodating professional requests is an easy accommodation, and I know that he knows that. So if you have a conflict, that he will accommodate that, because I know his dad would have required it too, so.
I'm sure we can work it out, Your Honor. But as we sit here right now, hearing set for October 23rd, and that's sort of the date I'm stuck with for these purposes, Your Honor.
Right. The only thing I'd suggest, without tipping our hand at all, is don't underestimate how quickly we can.
I appreciate that, Your Honor.
We understand not only the gravity of the situation, but also the need for speed.
And with that, if the panel has no other questions, I will take my seat.
Thank you.
Thank you.
All right. Mr. Coleman,
Yes, thank you, Your Honor. Obviously, we would accommodate. We've all been in that situation. That's kind of silly to imply otherwise.
and I know you
there-
would, I know you would.
So that's kind of ridiculous. Of course, there will be another date picked, and we would be getting with Ms. Howard today to do that. This just happened yesterday afternoon, as I understand, and I'm not at my, the court doesn't need to worry about that. Let me just say on a few points. I know it's been said a few times, the resolution controls over the minutes. The Tavener case and other sites that we have in our brief say the opposite, say that it's the minutes that control, because that's what records the actual votes and actions of the board. A later resolution is supposed to implement what is in writing in the minutes. And floor speeches or somebody saying something or asking a question, it doesn't change what's in the written minutes. And parole evidence, and we cite all the cases in our brief, is simply not allowed. You can't change the action of a board through statements of board members. If they're mistaken, or if they wrote it wrong, or they didn't do it the correct way, doesn't matter. It's what's in writing, and you can't change that with parole statements.
What if the signed minutes are inconsistent with the video of what actually happened at the meeting? Then what controls? I mean, don't you see the problem?
Well, Well, but they're not in this case, Judge. So I guess, if that hypothetical to arise in the future, I guess the court could grapple with it. But that's not the case here. The written minutes coincide directly with the video evidence of what actually happened at the board meeting. What doesn't comport with the video evidence in the minutes is the actual resolution that was later signed. And that's our whole point, Judge. And the logic of it, whether it makes sense to this court or to the trial court judge, is irrelevant. And under Youngkin, that's not this court's consideration. Now, I'd just like to touch briefly, if I could, on the due process issue. Again, this hasn't been brought up in this proceeding, but since it's been come into here, I think clearly under due process, actually, Judge Shapiro, we'd rely on your decision in the Schneider case, which we attached
That's a big mistake.
to our exhibit, where you said explicitly in this exact kind of scenario, a public office cannot be called property. And you said they are not subjects of contract or agencies for the state, revocable at the pleasure of the authority creating them. There is no property interest.
Remind me.
Now, that's not to say, I'm sorry, Your Honor.
That's fine. You said the Snyder case?
Schneider, it's attached. It was an unpublished Court of Appeals decision you wrote back in 2012.
Thank
And
you.
we attached it. And so we would rely on that. But secondly, the point is that it's not a question, it's a question of what due process here. And Ms. Howard's complaining about certain things. Look, we're going to be getting to her detailed process of how we anticipate this hearing would be held. We have retired Judge Thomas Brennan, who will be presiding over it, has agreed to do that. So we're taking steps to make sure, but there's constitutional due process, life, liberty, property, we're all familiar with. That's not an issue here. So the appellee is blurring these things, though that's not the due process we're talking about. The due process is what's required in 4611. That's the due process that's required. And we will comply with the law and we'll take those steps. So I just wanted to touch on that briefly, Your Honors, because it was brought up here. But again, Your Honors, I would say this. Whoever drafted the resolution, when it was drafted, all those things are irrelevant. It's uncontroverted that the resolution differs from the actual written minutes and the vote taken by the board. And I've never alleged there's any nefarious motive or anything that was kind of implied or anything like that. I simply stated the facts, that's uncontroverted and that's what happened. And so whether we think it makes sense, whether Your Honors think it makes sense, it doesn't matter. Their vote and motion and minutes says 3 contingencies. And so I'm just saying, from my point of view, I don't see how you get around that. You can try to explain it. The only way you can explain it is through parole testimony, which isn't allowed, or through people coming back later saying, well, that's not what I meant. Well, it doesn't matter. We all know the legislature passes laws all the time. And then individual legislators will stand up and say, well, I didn't mean that. I didn't think the law would be enforced that way. We all know it doesn't matter. It's what the words say. That's our point in this. Thanks. I'm happy to answer any other questions if you have it.
Any other questions?
No,
Mr.
thank you.
Coleman?
Thank you very
Okay,
much.
thank you. Appreciate that. Thank you both counsel and those in the audience for your time. This matter is being submitted and we will have a response to you very shortly. So with
Okay, thank
that,
you.
we stand adjourned and we will give folks an opportunity to file out at this point. We'll stand in recess.
Thank you, Your Honors.